world is changing rapidly.
And that's why private dispute resolution has never been more important.
The Chartered Institute of Arbitrators, also known as Ciarb,
is a global membership body of arbitrators, mediators, and adjudicators,
and other private dispute resolution practitioners.
We are the world's largest dispute resolution community,
comprising more than 18,000 members connected through 44 branches across 150 jurisdictions.
While no two private dispute resolution professionals are the same,
we are all committed to access to justice.
When it comes to training,
Ciarb is a global community and a global powerhouse,
investing and reinvesting both in our members and our profession.
Ciarb has set the benchmark with our chartered status,
which represents excellence in practice.
Our calendar of events, webinars, ongoing learning and lectures
are thought-provoking
and provide a chance for our members to connect and learn from each other.
Ciarb is more than a membership organization.
It's my professional home.
It's my professional home.
It's my community and my professional home.
Thank you. It's the most control I've ever had by just standing up and being silent at a podium. Thank you very much. Welcome, everyone, to this year's Roebuck Lecture, which is Damages and Remedies, Responsibilities and Reputation, delivered by the very noble, by Sir Robin Knowles CBE. My name, in case none of you know me, is Don McIntyre, and I am the new CEO of Ciarb. First and foremost, thank you for joining us here today at 12 Bloomsbury Square, and of course, virtually all around the world. It's very much appreciated. Before we start, just a few housekeeping notes for in-person guests. In case of a fire alarm, please follow the staff instructions and evacuate the building. I'm pretty sure you won't hang around, but just in case, please do exit the building. For our virtual guests, you can explore the virtual platform and the top navigation bar. During the sessions, please use the chat function on the right-hand side of your screen to interact with your fellow participants and let us know where in the world you are joining us from. Go ahead and try using the chat now if you'd like. If you need assistance with anything, please use the help widget, which is located at the bottom of your screen. The lecture is being recorded and will be available in our virtual platform immediately after the lecture and also on Ciarb's YouTube channel. If you ask a question in person, please note that you will be recorded, so hopefully it's a good question. If you would prefer not to be recorded, please do let us know before you ask the question. I'll hold you to that as well. We will take questions at the end of the lecture, both in the room and virtually. Lucy Greenwood, one of our trustees, will be leading the discussion for the virtual guest. Please do use the Q&A function on your screen to ask your questions. Obviously not for you guys, for everybody else. I would now like to welcome our speaker, Sir Robin Knowles. Just in case you don't know him, and I've learned this, Sir Robin is a judge in the High Court in England and Wales. He sits principally in the Commercial Court, and where he recently decided PNID versus Nigeria. Quite an impressive, accountable to an international steering group. Sir Robin is the judge with the day-to-day responsibility for the Standing International Forum on Commercial Courts. He is a member of the Financial Markets Law Committee and its governing board. Sir Robin has a career-long involvement in encouragement and coordination for legal pro bono, nationally, internationally, and chairs of the board of the National Pro Bono Center. Please, everybody, thank you, Sir Robin.
Thank you very much. It's very kind. Thanks very much indeed, Don. Thanks also for leaving me with my copy of the speech. I pay tribute to the late Professor Derek Roebuck. I am honoured to give this 15th lecture in his name and at the invitation of the Chartered Institute of Arbitrators. Some money awards in arbitration are now vast. There is no other word for it. Are they correct? I'm not sure that we are clear about what is correct. I am also not sure that we have developed what is needed to reduce the risk of error where awards can be this vast. I do not think we are ready, but I do believe that we could be. Correctness of result. In arbitration, we do not always spell out the importance of correctness of result. When we do, it is also very easy to find ourselves focused on liability and not so much on damages. Reflect for a moment on how the Supreme Court described arbitration in its decision in Fiona Trust. That the parties wanted their disputes decided by a tribunal which they have chosen, commonly on grounds of such matters as neutrality, expertise, and privacy, the availability of legal services at the seat of the arbitration, and what Lord Hoffman called the unobtrusive efficiency of the supervisory law. Of international contracts in particular, Lord Hoffman said, they want a quick and efficient adjudication and do not want to take the risks of delay and, in too many cases, of partiality in proceedings before a national jurisdiction. What is of note is there's no reference to the importance of correctness of result. Of course, there are reasons for that, and in one sense, it was taken as given. There's also, of course, the point that the importance of correctness is relative to the dispute. In modest cases, there is room for some tolerance in the practical interest of cost, efficiency, and time, as long as the result is fair. But when it comes to vast awards, let's be very clear and express the correctness of the result is really important. The consequence of error when it comes to calculation of loss is vast. We know that another thing that is really important in the context of dispute resolution and the rule of law is certainty with predictability. The presence of vast awards on the landscape is not currently sustaining certainty and predictability, at least while we are unclear about what is correct, and at least until we have developed what is needed to reduce the risk of error. Vast awards that we have seen brought with them a range of consequences. They have opened new scales of dispute about enforcement. They have encouraged more claims seeking vast awards. They have not helped the healthy development of commercial arbitration funding. Some disputes have become harder to settle, however strong the merits of the claim. This is because expectations are set high by other vast awards, and there is uncertainty. In other disputes, the threat of the scale of award has forced settlement, however weak the merits of the claim. The respondent cannot take the risk of a vast award, and there is uncertainty. There's an impact here on confidence and on reputation, and it's not confined to one area of arbitration. Indeed, it's not confined to arbitration alone amongst dispute resolution methods. The impact of vast awards with uncertainty is relevant to every area of dispute resolution at every level. Some of the vast awards and vast claims have been against states. But just as for a state and its entire economy, so too the consequence of a vast claim or award can be enormous for a business and for all those who invest in or work for it. But I would add a word about states in particular. States are users of the process of dispute resolution, that is arbitration. In courts, arbitration and mediation, users and potential users matter. Where we encourage states to use arbitration, we should make it our business to really know about states as users. A state is a user that is not just the government of the day, but it is a community of people, young and old, poor and better off, well and unwell. It is an entire economy. As for the government of the day, sometimes that government will not, for whatever reason, engage with a dispute in the way we count on for a dispute resolution process to work well. I said earlier that vast awards and vast claims have made some disputes incapable of settlement, and that the threat of their scale has forced settlement in other disputes. Let me try to show that in action in the context of the state as a user. A state contracted to allow long-term mining by particular methods. In time, the harmful consequences of those methods become better understood. The state introduces modern regulation. A claim is made against the state for preventing the old methods. The claim might produce a vast award. A vast award would be impossible for the state to meet. The state undoes the regulation as a result. Extend that example by imagining that that regulation was an essential contribution towards global efforts on pollution or environment or modern slavery or climate change. Let me turn to P&ID against Nigeria, not to the fraud and corruption in the case, but to how damages were dealt with. The dispute does, I believe, allow us the opportunity to ask questions and test our answers. On damages, the tribunal got to a figure of $6.6 billion US. Interest was to add more billions of dollars. The figure was a multiple of the size of the health and education budgets of Nigeria. In 2017, the year of the award, that sum was 1/4 of the entire budget for the entire nation. P&I and Nigeria had, on the face of it, contracted. P&ID agreed to build gas processing facilities. Nigeria would supply wet gas by pipeline for processing. P&ID would earn from the sale of the byproduct from processing. But P&ID did not build, and Nigeria did not supply. The contract was terminated by reason of Nigeria's non-performance. P&ID was held to be entitled to damages. And when it reached damages, the tribunal majority described the calculation in these terms. If the contract had been performed, P&ID would have received for 20 years an income from the sale of natural gas liquids extracted from the wet gas supplied by the government. As against that income, it would have had to finance the necessary capital expenditure to acquire the site and construct the gas processing facilities, CapEx, and incur revenue expenditure in operating the plant, OpEx. The loss is therefore, continued the tribunal, the value of the stream of net profit which P&ID would have made if the government had performed the contract according to its terms. As the damages have to be assessed once and for all, it is necessary to estimate the value of that stream of profit at the time of the breach, making an appropriate discount for the fact that P&ID will be awarded immediate payment in place of sums which would actually have been received over a 20-year period. On the expert evidence, about which more later, that gets you to $6.6 billion US. That figure eclipsing, as I've said, the size of the health or education budgets for a number of years for 200 million people. When it began the arbitration, P&ID's own open, on-the-record estimate of its loss was $1.992 billion US. The figure was 3 times higher by the time of the award. Of course, these uplifts can happen, and of course the case is decided on the evidence, but I heard extensive evidence and argument before deciding the challenge to the award. This allowed me to look in detail at what had and what had not happened. There is much on fraud and corruption, but for present purposes, I leave that aside and focus simply on how damages were dealt with. I said that there didn't seem to have been argument or consideration of argument, whether over 20 years profitability might deteriorate for reasons not connected with Nigeria's compliance with its obligations. For example, over 20 years, a hardening adverse position for gas in the context of a developing global response to climate change. Nor, as I said, was there full argument of the possibility that P&ID might, at least in time, have devoted profitably elsewhere the time and energies it would otherwise have had to devote here on this project. There was something about mitigation. And what of this point? Where in a case like P&ID, if not in that case itself, neither party has performed, are damages to be calculated in the same way if liability seems to turn on who called breach first? $6.6 billion. Any challenge to the tribunal's formulation that I've read out might test conventional legal opinion, and any challenge to that formulation might be unsuccessful. But it wasn't attempted. And this where so much turned on it for both parties. It used to be the case that small cases often discovered or developed the law, the common law, or showed up gaps. Now it's more likely that the larger ones do. They attract the investment of the legal resource that is capable of helping us develop the law. We shouldn't be surprised at the idea that the common law, in relation to prospective loss after repudiation, continues to be found and developed. just as in an appropriate case, we can do better than discounted cash flow as a methodology, and we know it. Let me take another example from P&ID and Nigeria. It concerns interest. Interest in its own right is a point of very real importance. A vast award would become vaster. In billion-dollar award world, hundreds of millions turn on this, billions even, as in P&ID against Nigeria. Nigeria found its own unsuccessful argument about discount rate rebounding on it when it came to interest. But no closer analysis was pressed for by Nigeria. The argument on interest, such as it was all over in a short period of time, and billions of dollars turned on it. The conventional idea of interest based on what P&ID would have had to pay to borrow the money or could have earned by investment in Nigeria was not challenged. There was no attempt to test that when dealing with sums so vast that in no real circumstance would P&ID be borrowing those sums or would have invested those sums in Nigeria. Let's take things a little bit further in the case of a state. Where do we consider the consequences of a calculation that results in an immediate award for sums that would and could never have been received immediately? Discounting for accelerated receipt is not a full answer. And we add interest for each delay in payment of the lump sum that would and could never have been paid up in a lump sum in the world of the contract. Again, it's the vast awards that tests what we're doing and where we may need to look again. In several respects, much of this is open to the challenge that it's simply not commercial to approach matters in this way at this level. Among the results is aggressive enforcement or attempts at enforcement before or after the possible start of transactions in the claim or in the award or in the claimant. These are just examples, but let me challenge you a little further with another example that I was pleased to identify in reading more widely. In the investment treaty, public international law context, Professor Parakinskis asks whether the size of award today opens the question whether the capacity of the state to satisfy an obligation to pay full compensation should be a legally relevant consideration to take into account when looking at the content of responsibility. He discusses the idea of an exception to the principle of full reparation in international law of state responsibility for cases where full compensation is crippling for the responsible state or its peoples. The professor may be right, he may be wrong, but the point deserves to be addressed alongside others I have mentioned and others that will be in your minds. What happens in arbitration where there may be more to be understood about the law than we had to date realized? It is a feature of arbitration that sometimes it is not easy for arbitration to deal with the question whether there is more to the law in an area or whether the law should be developed. In arbitration, in one sense, the apex tribunal is the tribunal. I suggest that it's here that we need an effort across the system of dispute resolution. I will be suggesting other respects in which an effort across the whole system is needed. But here, where points are decided in arbitration, and some of the world's greatest and most expert and experienced lawyers are arbitrators, we should at least strive for transparency of those awards, and perhaps greater visibility of the process, and the welcome academic analysis, research, and criticism to follow. Or we might look for the opportunity in another appropriate case to put points for decision to our courts by ad hoc agreement if need be. Would you consider proposing that a point in court is referred to arbitration, or that a point in arbitration is referred to the court? There's this point too. Working with experts who are not lawyers, we might examine whether we can develop quantum models not as a piece of expert evidence, to which I'll turn, but as a form of expression of a more sophisticated law of quantum. They could be with us, those models, from the start of the dispute resolution process. Would you raise the suggestion that there is more room for remedies other than money awards decided after the event? Should we be considering more room for declarations ahead of conduct that might or might not breach or terminate contracts? Should we be prepared to assess quantum ahead of contract termination, or at least ahead of a finding of liability? All of these things are in the true interests of those who choose arbitration. They are all in the interests of working towards certainty. Let me move from substantive law to evidence, and specifically to expert evidence. What is the work that the expert is doing? That is a basic question, but in practice the answer is complex. By this I mean no criticism. In litigation, it has taken many years for single jurisdictions to settle the principles of what is expected from an expert, and from the lawyers instructing an expert, and from the court when dealing with expert evidence. One jurisdiction will differ from another, but at least the dispute will be resolved within the corners of a single legal tradition. In most jurisdictions, perhaps all, even then it's still a work in progress, with the uncertainty that attends. But in arbitration, the answer to the question, what is the work the expert is doing, may be far more complex. The lawyers instructing the experts may be from different legal traditions. The experts may be from different countries or jurisdictions or parts of the world with different training. I have been struck in discussion with experts internationally by the different ways in which they see their task, or at least the uncertainty over this. Should they focus on putting forward the analysis that provides the best result for the party that has sought their evidence? Some will say this is acceptable if the expert called by the other party is doing the same. Another expert will see their task as presenting the available range of analyses, good or bad, for the party that has sought their evidence. One expert will expect to cooperate, another less so. One expert will consider revisions from a client, another will not. I am talking only of reputable experts. The expert who is the hired gun is a problem under any system. But the question that reputable experts raise is what is expected of them in arbitration and what they can expect of other experts in the dispute. Best practice statements and protocols have been contributed by leading arbitral institutions to their credit. These are helpful, but they are general, and perhaps necessarily general. There remain many, many different approaches to standards. The difficulties here are compounded where the opportunity for the expert teams to do their work may be very different. And when it comes to the responsibility of in-house counsel, legal representatives, arbitration funders in relation to the work of experts, is it clear what is required? What we ask of all of them and of the tribunal is all linked with the result that uncertainty can compound. The tribunal receiving the expert reports has the work product, but what does the tribunal know of what has led to that work product? Across the run of disputes, we cannot be clear. How tribunal members engage on this, when they may also be from different traditions, may also affect the result. So may I take the opportunity to go to P&ID again, and the opportunity that it gives us to look at this aspect. I will have to summarize, but there were these features of the expert evidence. First, the expert called by Nigeria had, as the tribunal knew and said, had very little time to prepare written reports. This was the fault of Nigeria, but it was also the fact. Second, the expert called by Nigeria, by the government, in the simple words of the tribunal majority, did not appear to have been shown Mr. Quinn's evidence. Documents apart, Mr. Quinn's evidence was the factual evidence in the case, and an expert had not been shown it, and the tribunal realized that and made that observation. There was, the tribunal majority found, misapprehension by the expert called by Nigeria about what P&ID had done and what material the other expert had done. Third, the tribunal recorded that points raised by Nigeria had not featured in the report of the expert called by them, or been put to the expert called by P&ID in the course of cross-examination. These included on matters such as cost of security, performance of employees, yield, sales, future income. On the top of policies that could, on the topic of policies that could affect pricing in the future, the tribunal said this: however, when the expert called by Nigeria gave oral evidence, he said that there were several forecasts available on websites which were different from a policy scenario that had been adduced by the expert called by P&ID. The tribunal continued. He did not, however, identify these forecasts, or websites, or produced them to the tribunal. The tribunal did not have the benefit of comments from the expert called by P&ID because none of this material, if such it was, had been put to him in cross-examination. Fourth, it was respectfully clear, and that includes clear to the tribunal, that Nigeria's leading counsel for the quantum hearing did not understand what the tribunal was putting to him in argument. This was not through any lack of clarity on the part of the tribunal, but it was the fact, and it was recorded as the fact. The four features are about competence, not fraud or corruption. Part of the function of experts as independent experts was to assist the tribunal, and the plain fact is that the tribunal did not have that assistance from experts called by Nigeria. In this situation, the tribunal majority relied on the expert called by P&ID. The majority said it was satisfied that that expert carefully examined all the available materials and exercised his own judgment. There were no grounds, said the tribunal, upon which to reject his estimate of capex. Turning to OPEX, the majority of the tribunal said that P&ID had made its own calculations of OPEX for the project under 6 heads and had arrived at a figure. The expert called by P&ID noted the majority of the tribunal said that he had reviewed these costs and considered they were reasonably accurate. You know that, respectfully, I did not consider that the tribunal did all that it could to find out more, here and elsewhere. When I looked at what was argued and what was not argued, I struggled to accept what happened in a dispute of this importance and magnitude. I was sure the tribunal was troubled, and I said so. I appreciated that views on what a tribunal should do in this situation will differ. I understand the points that can be made. The tribunal was entitled to rely on the parties' professional legal representatives to take the points that their clients wished to take. The conduct and effort of Nigeria's government, administration, and lawyers at the quantum stage of the arbitration was deserving of severe criticism. It was very clear that the tribunal and P&ID had met with many inexcusable delays from Nigeria, and it was understandable that the tribunal should manage the arbitration firmly in response. In a debate in Parliament in the House of Lords over the new arbitration bill, now Act, in this jurisdiction, in the course of a brief summary of the P&ID arbitration, Lord Hoffman said, "Eventually, at another hearing, we went into the question of what damages had to be paid. Arguments were again brought, with expert witnesses on both sides, and we came to the conclusion that it was a large figure because the gas was due to have been supplied over a period of 25 years and it all added up." You will anticipate the point that I'm going to make. The difficulty I have is that although there were expert witnesses on both sides, the tribunal did not have the assistance of a competent expert and competent expert evidence on both sides. In choosing arbitration, did the parties contemplate that a decision would be made in circumstances where the tribunal did not have assistance from both sides? Did the parties contemplate, when they chose arbitration, that the tribunal would be unable to try and bring about the assistance that was missing. So what could have been done differently? Please don't be concerned that in asking this question, we ignore the difficult job that the tribunal faced in P&ID against Nigeria. The spirit of the exercise we are discussing is about taking the opportunity to improve. In the debate in the House of Lords, Lord Hoffman himself said this was of the bribery and corruption aspects of the case, but it's material here as well. The question your lordships have to think about is, he said, what does that mean we arbitrators are supposed to do in practice? There are two ways to look at this. One is to ask, what would we actually have been prepared to do differently? Because it isn't easy. What would you actually do if you were the tribunal? The second way of looking at this could inform the first. It is to ask what the user would expect at the point when the arbitration agreement was made. In choosing arbitration, I suggest the parties seek a fair decision and a decision that is correct, especially in major disputes. We emphasize the other features of arbitration, but these are the ones at the heart of it for present purposes, however you phrase things. We may need users themselves to help us with the answer to this. They have often helped us with the answer in other areas, as courts around the world have found. And to call on their help rather than rely on our own expectation of what their position would be has its advantages. Would you have required the expert called by Nigeria to go back and read the evidence of Mr. Quinn and write a further report? Why not? Would you have invited Nigeria late? Yes, but to put the points it had not put, even by calling the experts back? Would you have taken the initiative as the tribunal to bring in another expert? Of course, there are arguments for and against party-appointed or tribunal-appointed experts, but decisions have to be made, especially where things are not working, and that things that might compromise the ability to decide fairly and correctly. With the benefit of knowing what can happen, as in P&ID, would you in the future, in fact, spend time with the experts before any reports are written, to ask what they proposed to do, to make clear what would help the tribunal, to discuss how the experts proposed to exchange and test views, to ascertain what the experts needed to do a good job, to establish proposed assumptions. Professor Doug Jones has spoken recently on the importance of identification of assumptions, and respectfully, he is right to do so. I add here that many experts to whom I've spoken over the years say they would welcome the opportunity for earlier involvement in one form or another, whether or not directly with the tribunal, and they say the same for litigation in the courts. And once it was clear that Nigeria's advocate didn't understand the points that the court was putting on quantum, would you have done what was needed to ensure that arguments were raised and explored by other means, perhaps by appointing counsel to the tribunal? There's the related question of course, whether if parties don't raise a point, the tribunal should nonetheless propose submissions on whether there is any more to the law or to its development. You will know that it is my argument that this is within, rather than outside, the process that the parties have chosen when they chose arbitration. I know that if arbitration is adversarial, there is sometimes a fear about the tribunal risking the appearance of partiality by what's termed entering the arena. But we can do better than allow vast awards to turn on whether a point is put or not, or whether questions from the tribunal are understood or not. What we're looking for, and we should be proud of, is a tribunal that is striving to equip itself with the assistance needed to produce an impartial result. Seen in that light, a hands-on rather than an over-detached tribunal should be uncontroversial. We have things to learn from our civil law colleagues who understand that investigation is not partiality. Overall, this is an area for the tribunal to have confidence in itself. That includes the courage to examine relatively radical ideas that might challenge our traditional assumptions. Though much of what I have suggested, I don't think is really radical. So much discussion that we have had about courts and arbitration has been about enforcement. The New York Convention is important and a true achievement, but it is not an entirely great friend when it over-dominates the discussion between courts and arbitration in the areas that I have sought to cover. Courts and arbitration need to take time together on other things so that they are surer of each other. If arbitrators strove to ensure that they had the expert or legal assistance that they needed, or themselves raised legal issues at the cutting edge, do we really fear that the courts, the supervisory courts, would arrest their support for arbitration? More generally, and across dispute resolution, it is time to move on from marketing and competition between dispute resolution methods and between jurisdictions. These are instead times for shared best practice, for collaboration, and for integration. We need more principles of law or practice to be developed, and for this we need all hands. Let's aspire to see the whole relationship between litigation, arbitration, and mediation as an integrated one. The issues of culture, standards, external expertise, and development of the law are universally relevant. It is together that courts and arbitration and mediation form a system, and this system is today international and needs to be forward-looking. It is vital to stability and to economies through the rule of law. We will need that system all the more as law helps us in a world of ever-increasing complexity, of AI, of poverty and inequality, of further definition of corporate responsibility, and of climate change. Each of these challenges and others will require us to look further at the law, and as we do, we will find more from it. The different perspectives that courts and arbitration and mediation can bring to rights and to interests may unlock some of the problems that come with vast awards. Awards that one party will struggle to enforce and the other party may struggle to survive. We are brought more in reach of what the Hon. James Allsop, former Chief Justice of Australia's Federal Court, has called a culture of problem solving that goes beyond black letter law and discrete processes and instead focuses on the sensible and effective resolution of disputes as part of a system. I can hear the users supporting. We now have the institutions that can help with this collaborative dialogue across countries. In one of those coincidences, when the award in P&ID was made in 2017, something else started, and that was something close to my heart called CIFOC, the largest gathering of commercial courts and judges from around the world. But what's notable for present purposes is that CIFOC was joined by ICA in Doha last year for a global meeting of judicial delegations from across the world. And only last month, this institute, the Chartered Institute for Arbitrators, joined CIFOC in Africa for a meeting of judiciaries focused on effective dispute resolution for that continent. At CIFOC's fourth full meeting in Sydney, the Chief Justice of Singapore, Sundaresh Menon, gave the keynote address to judicial delegations attending from every part of the world and every legal tradition. In international commercial dispute resolution, he imagined a regular dialogue among judges, arbitrators, and mediators to raise awareness and understanding on all sides with a view to working towards a set of shared perspectives on key issues. He took, and this is notable too, he took the opportunity to record that this was precisely what Judge Dominique Hascher, representing ICA, the International Council for Commercial Arbitration, had suggested at the same full meeting. Thank you for your kind interest in this. Will you please bring your ideas into the work that institutions and others can do to bring about change across the system? Whatever our individual role, every one of us has responsibilities here to the rule of law and the public interest. This is urgent because vast awards that we cannot be sure about are here with all their consequences. But it's also a lifetime's work for each of us. It's about culture, approach, and commitment. But at heart, the answer to the question, can we do better, is a firm yes. The great thing is we know we can. Uncertainty today over vast awards is capable of opening up improvements in dispute resolution if we take the opportunity to work out the solutions together. We all have a part to play in this. Thank you very much.
Wonderful. Well, thank you, Sir Robin. Absolutely fascinating and thought-provoking lecture, and on such an important and I would say far too under-considered subject. So a real challenge to us all there. And I think particularly Sir Robin's focus on the user perspective, the user's voice is far too often not heard enough in this process. So thank you again, Sir Robin, for that lecture. We have the opportunity to hear from you all here in the room, and we also have the very engaged online audience. So please don't be shy. We have the opportunity to keep Sir Robin here for another 25 minutes or so let's do that. I'm going to start with one of the questions that we had online, and then I see we've already got some questions here in the room, so thank you for that. The question online, and Krista's going to read it out very kindly for us, but it largely goes to one of the points you touched on, which is that elusive standard of reasonable certainty, proving damages with reasonable certainty, Sir Robin. So if I could ask Krista to read out the question, please. Thank you.
Can everyone hear me? Okay, it's coming through. Yes, this is from a damages and valuation expert from Singapore. And he says, what are your views as to the expectations of certainty when there is inherent uncertainty in the damages assessment process?
Thanks for the question. I think that what we've got to be careful about is expecting too much from a term, whether it's reasonable certainty or anything else. We're in an area here where there's no substitute for more detailed discussion of individual situations and sets of circumstances. I mentioned in the speech designed to provoke thought that one thing we could try and work out with the assistance of experts is whether there are models that would articulate what it is we're trying to do and make a contribution in that way. That is an example of a form of expression that may be more useful. I think I know this has been done, but it could be a very, very rich occasion if one assembled a lot of thoughtful people and said to them, now, let's discuss reasonable certainty or something like that. We would learn what a range of answers that gives. From there, we would start to work out whether there's a better way of expressing it. But more often, I think, we would come away perhaps with some scenarios and situations to which we could give a better result.
And I think if I can jump in on that, I think in this process, there's an awful lot of focus, as Sir Robin said, on liability, on establishing whether or not there was a wrong. And I would say, taking again from your excellent words, Sir Robin, that not enough focus on how you right that wrong if the wrong has been established. And just to that point, we're all very intimately familiar with what a balance of probability standard is, but we don't do the same kind of, I would say, forensic analysis of this sort of mythical standard of reasonable certainty for damages. And it rather goes to your point about how we can test the experts more. And so I'd be interested if you wanted to sort of elaborate on that, Sir Robin, because again, often this is simply the usual way of cross-examination. We sit as arbitrators, we hear the cross, and we make value judgments based on that. But help us a little more on your general thoughts on that.
Well, I mentioned two things, again, to sort of provoke discussion that really we could start bringing about right now because they can be brought about on a arbitration by arbitration basis. And we'd not only help the dispute, but I think we'd learn a lot more generally. And the first is time with the experts right at the beginning. Yeah. And it may be that one's got to push a bit to get that to happen, but part of what I'm suggesting is now's the time to push. The second, and it's a related thing, is that the experts are in a polite and reserved way saying, hear us. And so the more often we can be sitting down with them, even in an arbitration or, frankly, in a court hearing, for the sort of discussion that I mentioned about their work and about how they can make the best contribution, whether that's at the beginning of the case or further on. It seems to me the least suitable situation as a general approach is that we come across the expert for the first time when we're reading reports, however we might have been trying to frame the issues, and we hear them for the first time when they're being cross-examined.
Absolutely. And I mean, arbitration is such a front-loaded process in many ways. It may well be that we haven't sufficiently focused on front-loading the quantum rather than always front-loading the liability. I know we have lots of questions in the room, so thank you. There was one right at the back. I can just see the blue sleeve. Yes, do go ahead. Audley, sorry, with the blue sleeve. Do introduce yourself.
Audley Shepherd, 20 Essex, Vice President of Vicar. Thank you, Sir Robin, for your very insightful comments. You identify, if I may respectfully say, rightly, on the difficulties that flow from full reparation, a doctrine that is very well entrenched in English law for breaches of contract. I also expect Nigerian law, also international law as a result of Chortsov-Factory. And I think it is the size of damages against states which has turned states against ISDS and investment protection generally, not necessarily holdings of liability, because many states have administrative law and judicial review that can hold states to account, but it's the size of damages which is an affront to the state. You asked for suggestions. One suggestion I have and put out there at other times is to consider loss of a chance as an approach to damages. I say this because I had a case some years ago against Nigeria. There were some parallels in that a power purchase agreement was signed and terminated after 8 days. A claim was brought for many hundreds of millions. The tribunal found on liability against Lagos State and against the government because of the guarantee. There was no question of fraud or corruption. It was very ably defended by an SAN, one of Nigeria's leading advocates, very well known, very able. And when it came to damages, of course, the client was pressing for many hundreds of millions of dollars. But the tribunal looked at that, and the fact was no site had been chosen, no feedstock agreement had been entered into. Amongst other considerations, they thought that it was reasonable to assume that construction could be delayed and probably over budget, and that would affect the whole financing of the project. As a result, they said there were too many uncertainties. They would approach it on the basis of loss of a chance. They made considerable discounts to the total top-level claim, and they eventually awarded $11 million. Proportionate? Was the client unhappy? Of course, the claimant was very unhappy. Proportionate because there was liability. There was wrongful termination of the PPA. But whatever profits might have been made was too uncertain. So I thought it was proportionate. I thought it was reasonable. It recognized wrongdoing by the other contractual counterparty. But it wasn't it wasn't a massive amount of damages. And I wonder whether if we looked more seriously, and it may need some variation on orthodox theory about loss of a chance doctrine. But I think if we approach some of these claims when projects were at very early stages on that basis, I think we would come to a more reasonable and perhaps acceptable result for states as a result.
Thank you, Audley, and excellent point. And also it goes to one of the points that Sir Robin made, a fairly radical suggestion in his lecture about, the possibility of looking at damages even before liability, because if that had happened in the example you gave, then everyone would have been far clearer as to what they would actually be going to recover. But Sir Robin, do you want to comment on the point that was made?
I'd love to, actually. The first thing to say, though, is that the last idea that deal with damages before liability very much came into my mind as a result of conversation with Lucy. It just shows. And the first point I'd make in response to Audley is thank you, because that's in the spirit of trying to bring forward ideas. In relation to the particular idea, which I think has got a contribution to make, I'd just emphasize these things. First of all, if we head that way, we need to resolve the uncertainty about which cases are in the loss of chance bracket and which cases are not. I think that's uncertain in the courts and it's uncertain in arbitration. But at least we know what we're trying to aim at there. Secondly, although Audley has emphasized states, and I know I did to a degree, this is an issue that goes beyond states. It is really important in a world that is full of corporations and business. They're all looking for this to be approached sensibly. But Audley has set a great example underway.
Yes, thank you very much. We have more enthusiastic questions in the room. Thank you, and I'll be coming to online as well. I think the question just here. Sorry, yeah, I'm not really. Yes, that's right. Oh, well, we'll go to the one in front of you next, but you go ahead. Yes, please. Sorry, it's difficult to see you at the back there. Yes.
Thank you so much.
Do you introduce yourself?
Oh, my name is Tabo Chakakanyamenda. I'm the Attorney General of the Republic of Malawi. Coming to the awards, huge awards that Sullivan has alluded to, particularly to the PIG case, wouldn't one of the suggestions be, as I think a number of English court cases have decided, where you have exaggerated a claim, then the findings that claim is founded on fraud and deception, even though they can award some nominal, or maybe, let's say, for example, the actual award, the actual damage could have been $100 million or $10 million, but you have put forward a claim for compensation of $10 billion, and then you should lose on all fronts on account of you exaggerating the claim and on the basis of fraud and deception. I think there are a number of English court cases on that point.
Thank you very much for the question. Did you want to comment on it, Sir Robin?
Again, I think we should welcome all ideas. I'm cautious about the idea that comes in with a solution that is what I would say is late and is going to be approached in quite a reserved way, I can see, by courts and tribunals. But thank you for the suggestion.
Thank you. We'll take one question online and then we'll come to the gentleman in the blue suit who I know has been waiting, so apologies, I don't know your name. But Krista, I think you had a question about the finality of the arbitration awards.
That's right.
And court intervention.
That's right. This is a question here from the chat that says, do you see a future where courts intervene more actively in reviewing arbitral awards for public interest or proportionality, even at the risk of undermining finality, especially in cases involving state entities?
It's a really important question. I do not see the quantity of court intervention increasing.
Oh, good.
But I think on the few occasions, we should be, on the few occasions when it happens, that should be viewed positively as the system working. But I touched in the lecture of the idea of actually thinking about bringing some points of law through to the courts. If the parties have got their arbitration agreement, but it doesn't stop a sensible conversation that says actually this point, before anyone starts deciding it, is one that one might put before a court. It's of wider interest. I think the problem at the moment, which is not doing anyone any good, is that a great deal of time is necessarily being consumed in the space of enforcement battles over very large awards. That's not the most productive way of the relationship working. It's necessary at the moment, but I hope we can move on from that.
Thank you very much, Sir Robin. We'll come to the gentleman in the blue suit. We've been waiting patiently. Do go ahead.
Nasser Khan, a reputable quantum expert.
Thank you, Mr. Khan.
So, Robin, my question is, it's a very similar case, PNID, and when we look at the Rico Dig case, Pakistan, one was set aside by the UK courts while the other wasn't. Was it because one was commercial arbitration or one was investor state? How do you see the difference of loss of chance and termination, fraud, investigations, and all of that between the two cases? How? Because to me, they are very similar in nature in that, but one was set aside and one wasn't. How do you see that?
Yeah. I wouldn't achieve very much if I sought to reconcile the two specific cases, but we should expect differences. I think that between cases, whether they involve states or companies, it is in fact different outcomes that can help us in the end develop the law. The area of difference between a state and a corporation that I would keep in mind was the one that I tried to mention in the talk. We have to recognize that a state will be in, from time to time, in a situation where it's actually difficult for it to engage with a dispute in the way that we, as involved in the dispute resolution sector, would like. And I think we've got to be smart as to how we work through that. In PNID, the tribunal gave more time and more time still, and in the end said, well, you've had your time and we're going to now deal with it. It's in that context, I think, that perhaps a tribunal would see, well, there's something going on there that is causing this foolish approach. And it's an approach that damages the whole population. And it might be an approach that's a result of some terrible bureaucracy. And that causing the tribunal to think, how can I cut through this? And one of the ways of cutting through might be to say, right, we're going to bring another expert in, or we're going to bring another counsel in. But what we not going to do is just say, well, you've had your chance. We will proceed without the benefit of the evidence we need to get a fair result, or the argument we need to get the law right in a respect that may be very, very tricky because the awards are very large.
Absolutely. Absolutely. Thank you. More questions in the room. Yes, gentleman just in front of Chikwendo. Yes. So not Chikwendo, the one gentleman in front of you. Sorry.
Thank you. Yes, good afternoon. Thank you for that wonderful lecture. My name is Amir Singh Pasrich. I'm here from next door, New Delhi. Just dropped in. I'm also treasurer of the IBA. My question was very simple. You mentioned in the course of your comments that arbitration, mediation, and litigation should come together as dispute resolution mechanisms that work and perhaps tie up, have better, stitching, put them all together.
Yeah.
And I was wondering why arbitrators are not permitted to be amiable compositors as much as they should be. And the same happens even with courts. Sometimes they don't see the opportunity to understand a dispute and force the parties into a mediated position where they know what's going on. And it's better to do that with agreement rather than a judgment. Thank you.
Thank you very much for the question. And what immediately occurs to me is how you feed that into improving predictability in arbitration awards if you bring in that greater ability to act as amiable compositor. But a wonderful question. Thank you. So, Robin, what are your thoughts?
Above all, it's the broad conviction that the more time we spend together as litigators, arbitrators, and mediators, or those involved in any of those processes, the more we will identify solutions that are workable when we're going to use them, and it's that will help certainty.
Yes.
It will also help certainty in the sense that not only do we arrive at an improved fashion in which one form of dispute resolution could operate, but in the process, everybody else in that conversation understands why and what is sought to be achieved. So there is not only a developed process, but there's a general understanding of why that's a good move.
Thank you very much. Kristen, anything online, or I'm very happy to take more questions from the room.
Yes, maybe we have a few questions, some of which you've already kind of touched on, so maybe we'll yield the floor.
Sure,
back.
Absolutely. Who's desperate to be heard in the room? Go ahead. You're the first I saw. Yes, go ahead.
Hello, Sir Robin. My name is Saad Higazi. I'm one of the Ciarb trustee and also a reputable expert, as Nasser. So thank you so much for the wonderful lecture. It's actually touched every one of the experts and also in arbitrators. One of the things you mentioned was about the existing practices, and you said the guidelines governing expert involvement in arbitration are often sometimes too general.
Yes.
Okay. So in the light of that, do you believe the arbitral institutions, for example, should move towards like some kind of requiring more religious or case-specific methodologies from the experts, specifically in cases like the one we were talking about, Nigeria versus BIND, which have a public interest or state entities? How can we fix this? Because experts goes to arbitrations and everyone is selecting different methodologies, and even with these what we call so-called general methodologies or general guidelines, it's very hard to agree on specific issues.
Like all aspects of this, it is not easy. I do think the institutions, encouraged by us all, can work towards greater specificity in some of the guidelines and protocols. I do not believe that that will resolve this as opposed to make a contribution to it. I think the real contribution will come from the way in which the arbitration community as a whole engages with the providers of expert evidence to live a better process in the course of each dispute. If we were to bring early engagement between tribunal and experts, we might find that in the early days we were building a structure sort of case by case, but it would soon surface which points could be a bit of a template for another case or series of cases. I can say on the court side, on the litigation side, we have found it helpful to have more detail in protocols and statements and the like. But that's more easily achieved, as I said in the lecture, if one is just dealing with one jurisdiction and one can say, well, that's the position, comply with it. I'm not sure we'll get there if we rely on that approach to resolve the position in arbitration. So the institutions can continue to make their invaluable contribution, but a lot of this is about each one of us deciding to approach this day in, day out, arbitration in and arbitration out.
Absolutely, thank you very much. Now I know Chikwendo's been very, very patient back there, so do put your question.
Thank you very much, Sir Robin, and thank you very much, Lucy, for this opportunity. Now, please, you allow me to make 2 short comments and then ask a question. Number 1 is, my name is Chikwendo Madumere, I'm a Nigerian. And Sir Robin, I'm so happy seeing you today, and I want to convey to you the gratitude of Nigerians, for saving us from the yoke of PNID. And number 2, I want to also congratulate you for the initiative of this collaboration, because I raised a question at a webinar, in Nigeria, and I asked a question. I said, as much as we are happy with the decision that you gave, let's reflect and ask ourselves a deeper question. If that appeal or if that challenge was before a court in my country, could the outcome have been the same? That is a question we need to ask ourselves, and that is why the collaboration comes in. We need a lot of support from your initiative, and I'm sure a lot of our jurisdictions will be very happy to collaborate. Now to my question. I want you to clarify for me the suggestion that you made with regards to how a tribunal could on its own appoint an expert. I ask this question because I keep in mind that under several procedural rules, the burden of proof lies on each party, either the claimant or the respondent for the defense. I mean, how could a tribunal navigate those nuances when a party is unwilling to bring an expert? How far could a tribunal go in supporting a party in proving his case, considering the fact that if a tribunal goes ahead to appoint an expert, it has an implication of cost. So where should a tribunal say enough is enough?
Thanks. Thanks very, very much. It deserves a fuller answer. But let's put at the forefront of our mind the fact that the expert contribution is there because it's an independent contribution. Whoever has hired the expert it is for the purpose of producing independent expert evidence to the tribunal. And if the tribunal finds itself in a place where it's given permission in the process for there to be independent expert evidence, but one of the expert team is simply not making its contribution, then it seems to me a small step to bring in another expert. And that is not favouring either side at all, because what's being brought in is independent expert evidence. I am absolutely aware of how difficult that might be in an individual case, but if it's one of those things, isn't it, where it's either that or you get the sort of thing that has surfaced in the PNID Nigeria case. And put that way, there's only one way.
Absolutely. I'm going to take one last question, a very short one, if we can make it that. I think you had your hand up before in the green tie, didn't you? Do go ahead. And please introduce yourself. And a short one, it's going to be our last question. So no pressure.
So Robin, yes, Freddie Simpson, I'm a barrister here in London. You spoke about the correctness of awards. I was wondering if you just flesh out what you have in mind when you're talking about correctness.
Just an easy one to finish on, Sir Robin.
It's, as I think I also may have said, I'm not even sure we know what correct is, but it's the accuracy of the result. And that means sometimes working through to a next level in the law that applies, or working past some of the too obvious contributions of fact or expert evidence when one knows there's more that needs really to be found to get to the right answer. Maybe the right answer is the way a user would put it. Maybe, with real gratitude for your question, that's a question, what do we mean by correctness, that we should put to the users?
Thank you very much indeed. And thank you to everyone online as well for their really great engagement throughout this fascinating lecture. Thank you to everyone in the room. Early on in Sir Robin's wonderful remarks, he did say, and I quote, "We can do better than discounted cash flow, and we know it." Well, Sir Robin, we do, and we will. So thank you very much indeed. Thank you.